Lordship, I beg to mention item number 6, Lordship. Here we have filed an affidavit yesterday, Lordship. This affidavit may be called for, Lordship.
And that will bring, what do you say, gentlemen? You are for the petitioner?
Petitioner, my lord. Can this matter be taken up at 2, my lord? The arguing counsel has some difficulty in the first half.
Yes,
The arguing counsel has some difficulty in the first half. Can we still take it up at 2, my lord?
depends. You have to keep us busy till 2. Then only. You can't expect us to rise after completion of board and then sit back because council is not
Can it
available.
be taken up at the end of the list then? May I?
That we can do, no doubt.
Apply to this. Apply.
Is it transfer matter?
Yes, my lord.
Get their affidavit.
May it please your lordship. Lordship, item 49, with the consent of the other side, we're praying for some more time. We're trying to reconcile with the rules, lordship.
Okay, then counsel for the petitioner, praise for
No,
time.
lordship, for the respondent.
For the respondent, praise for time. The other side has no objection.
No, we have given a slip also.
Consent has been taken from the other side, sir, from the petitioner's counsel. Please stop summer vacation.
Much obliged, lordship.
May I please, your lordship? I like to mention for listing my re-repeal, my lord, on Thursday, my lord.
All right.
Public,
When was the single bench order passed?
on 16th,
Okay.
this month.
That is listed.
Public.
Lord, I also have a prayer for listing of a writ appeal, my lord. This matter was already listed for hearing. The petitioner, my lord, he is suffering because his pensionary benefits are also not being
Hearing
paid.
matters, Mr. Counsel, no, not possible.
Also vacation, my lord.
Vacation, it will come up automatically. Why you are worried?
There is no date.
Ms.
fixed.
Chaudhary has already given us a lot of homework. We have to complete that.
My lord, I understand. Deeply obliged.
Make a mention after vacation.
My lord.
My lord, may it please, my lord. I have also the same prayer to list for hearing every appeal matter.
Hearing matter, madam. You know, I don't know what is the procedure here, but the appropriate procedure to my mind, if you want to get a hearing matter listed, is to file an application for early hearing. There must be a provision in rules. Mr. Mahanta, is there a provision in the Guwahati High Court rules for making a application for early hearing?
No, my lord, there is no provision.
There is no provision.
But there is a convention. If required, we file a
Yes,
early hearing petition, we file.
we will look into it because there has to be a proper provision whereby a application can be for early hearing. All right,
Must
so you move an application, we'll pass an order.
My lord, must oblige.
My lord, I need to mention for listing of an interlocutory application filed on 15, my lord.
Get it listed.
My lord.
No, already instruction was there. List them. Already, yes.
Daily list for orders, item 1.
You file your affidavit?
My lord, status report, my lord, that the land has already been allotted, my lord, and the acquisition proceeding completed. We are filing it today, status report. And the another affidavit, my lord, we have already translated the, my lord, copy of the land records to the English, my lord. We want to file it by way of affidavit, my lord. At least, my lord, till Monday,
Acquisition of which land?
acquisition of land for the national highway, my lord.
Okay, that acquisition is
Yeah,
complete.
Has already been completed. We have filed a status.
But their
report today.
grievances regarding the things which have happened in the acquisition only.
Only by.
You are required to file the affidavit.
My lord, in fact, there was an order by this honorable court whereby the principal secretary to the Hilarious department was filed an affidavit. That affidavit has still not been filed till date, my lord.
That's what we are pointing it out.
Yes,
Yes. Principal secretary, that was the direction we.
yes, my lord. And on the very day when the notice was issued, that order was passed.
Principal secretary, Hilarious department.
10/9/20 probably.
Yes, my lord.
10/9/20.
Password.
10/9/2020, yes.
We direct
We
the
further direct secretary to the Hilarious department.
secretary to the Department of Hilarious to file his personal affidavit, which has to be parawise. This order we have retreated. You want us to direct the secretary to be here on day-to-day basis, you will direct. 3 years, the order of this court has not been complied.
Malad, Lordship, give me 3 days time, Lordship, it is not within my notice below.
It was
It is not within my notice.
7/6/2003. We had
Correct.
again
Lordship,
8/5/2023, same order
Lordship. So it is not brought to my notice below. Lordship may give it
was appearing
on Friday.
on these two dates. Correct. Mr. Nath, Government Advocate Mr. Nath puts in appearance on behalf of the Secretary Department of Hill Areas and assures that affidavit on behalf of the officer in terms of the order dated 10/9/20 shall be filed positively by next date of listing. We hereby make it clear that in case the affidavit as directed is not submitted by the next date, we shall be compelled to require the personal attendance of the officer in this court on each and every date of hearing. Re-notify on 19 July.
I'm obliged.
What is this IA about?
My lord, my lord, we have the principal secretary of Karbi Autonomous Council filed the IA, my lord, stating that, my lord, they have filed a publication in a newspaper in the name of the Chief Justice, my lord. So we bring in notice to the Honorable Court, my lord, by that, my lord. And that before
Yes,
the time
Mr.
of-
Chaudhary.
My lord, before the time of election, my lord, that was done, my lord. So we bring in notice at that time, my lord.
That was
IA
News-
37 of
news-
2022.
where is the publication?
Publication, lordship may look into, my lord. Annexure 1, page 11.
Annexure 1.
It is the name of the Chief Justice and the name also be published, my lord, in the newspaper. And though we
Subsequently,
have-
some corrective steps were taken, my lord. I don't remember exactly.
Even the newspaper is also at fault.
Ah,
The publisher should not have allowed this kind of.
yes, yes.
In the name of the, my lord, judge, my lord. It should be
Absolutely.
filed in the name of registrar, my
No,
lord.
no, there is no doubt about it, my lord.
Have you responded, sir, to this IA?
No, certain, no, my lord, will do, my lord, will do. I think, my lord, actually, my instructing counsel, she has become a mother, so is not present. I could not be, I mean.
All right.
I-
In the in IA number so and so,
Corrective steps,
Mr.
whatever is required.
Ms. Chaudhary assures that corrective steps required to be taken shall be completed in
Before the
relation to
next
the
date.
amendments made in this application by the next date of listing.
I have a small submission. On behalf of the respondent number 4, an affidavit has been filed with the deputy secretary. And it was.
No, Mr. Nath, the direction was
Lordship,
personal affidavit parawise.
lordship.
And that direction we reiterated. We knew that the
Hmm.
deputy secretary had filed the affidavit, but the direction was to the secretary.
Lordship.
Yes.
Item number 2.
Affidavit on behalf of the respondents.
I'm appearing for respondent number 1, 2, 4, and 5.
4, 5, and 7.
1, 2, 4, 5, yes. 7. Seven is my.
You will be appearing. NHI. Okay, 7
Lord,
should be available.
I prefer further 3 weeks time. I have
And
not received the instruction.
What about your affidavit, sir?
My lord, we also play, my lord. just-
Then counsel for the respondents, pray for and are granted further opportunity of 4 weeks to file affidavit in opposition. List up 4 weeks.
Item number 3.
Item number 3, my lord, in this case, my lord, the step on the respondent number 6, private has been taken, my lord. Now service report is awaited, my lord, as per office record of 16/6/2000.
Respond number 6.
Yes, he is a private respondent. Otherwise,
So-
government has accepted.
Service report has not been,
Yes.
do you require that it should be awaited? Because no point awaiting
It is, my lord, just a few days.
fresh notice. Because it was 4 weeks notice on 28 foot.
Oh,
All right,
yes.
await return of notice issued to the respondent number 6. For 4 weeks.
Item number 4.
Well, in the condonation petition, Lordship has directed issuance of notice. We have
Notice.
taken step, Lord. We have already taken step. Lord.
You have
Possibly-
taken steps.
Yes, we have taken steps.
Well, and await return of notice issued to the respondent number 1 for 4 weeks.
May I prefer a date, Lord?
Await return of notice issued to the respondent number 1 re-notify on 19 July.
Shall we take fresh, Malad?
All right, then, at the request of Mr. Nath, let fresh steps for service of notice be taken on the respondent number 1. Dasti services.
Malad. I'll try, Malad, to get Dasti.
Dasti services. Rule is made returnable on 19 July. List on 19 July.
Item number 5.
Your Lordship. For condemnation 15 days, my lord.
Who appears for the respondents? Have you supplied copies? Madam, you are appearing for all respondents? No. Commissioner, Secretary, Education Department, Elementary Education, Chief Secretary. You will be appearing. Finance. Pension. Do you have any objection? 15 days delay.
No, my lord.
The connected rate appeal is delayed by 15 days. IA number so and so has been filed under Section 5 of the Limitation Act, seeking condonation of the delay. The prayer for condonation is not opposed by the respondents' counsel. Hence, the delay is condoned and the application is allowed. The connected rate appeal shall be numbered and listed for admission after summer vacation. Then counsel for the petition shall in the meantime supply copies of the petition to respective government council appearing for the departments. List the appeal for admission after summer vacation.
Item number 7.
This, my lord, the appellant herein has been working as a laboratory.
He is not qualified, he is not qualified. What is the escape route for him? Can you dispute the fact that as per rules of 2017, he is not having a graduation? How can he claim promotion on that post?
Admitted, my lord. Rule was silent, my lord, for which, my lord, this.
The rules earlier were silent.
Yes, my lord.
All right. So you claim that you gained the entitlement to be considered. It was not done. The right is only to be considered.
Yes.
In the meantime, new rules came into force.
Yes.
Upgrade yourself, get a graduation degree. What prevents you from doing that?
My lord, page number 60 is the notification, my lord.
60.
60 is the prescribing the qualification, my lord.
Yes.
It was absent in the rule, my lord. But my lord, what my lord came to light, my lord, in this notification, my lord, everything, my lord, mentioned regarding the direct recruitment, my lord. Regarding the age and qualification, my lord, guidelines, page number 60, guideline number 1.
This is guideline. Where are the rules?
Yeah.
Are the rules silent on this?
The rule silent, my lord.
Where have you argued this in the single bench?
Yes,
Let's see.
Assam College employees provincial rule, my lord, 2010. Assam College employees provincial rule. 2010.
Come to para 18.
Yes. Para 18 of my lord, that's my lord.
No, para 23.
My lord, it is to be noted, my lord, that even for the provincialized for government secondary and higher secondary school, the state as per provision of Assam Secondary Education Rule 18, that came post 19, grade 3 assistant and library assistant candidates must be graduate and must have computer knowledge further like the provincialized colleges in provincialized secondary and higher secondary schools of the state. With regard to the post of grade 3, there is a provision for promotion in the quota of 5% from amongst the grade 4 incumbent serving in the such schools.
So graduation is an essential qualification.
Yes, my lord. That is regarding, my lord, secondary education, my lord. And petitioner is, my lord, college.
No.
Assam college employees provincial rule. He is covered by the lord. Assam college employees provincial rules 2010.
Okay. All right, then issue notice to the respondents. Appearance, mark the appearance. So and so put in appearance on behalf of respondents. Sufficient copies of the writ appeal be provided to respective counsel representing the respondents. pray for and are granted 4 weeks time to complete their instructions. 4 weeks.
Item number 8.
Yeah, please, Your Lordship. Lordship, I am appearing for Mr. Gupta, currently CVC. Your Honor, today morning only he has been allotted this matter. Your Honor, 2 weeks time may be given to obtain instruction now.
He stated that council, standing council, Mr. H. Gupta
Yes, my lord.
will be putting in, has been instructed to appear on behalf of the respondents in this writ appeal. A prayer is made to defer the consideration of the matter by 4 weeks so as to enable Mr. Gupta to complete his instructions.
May I pray, Lordship? Let this matter may come after vacation, Lordship. And Lordship, with all respect, Lordship. Lordship, since they have filed their affidavit, Lordship, already in before the Honorable Single Judge, Lordship, it's purely a question of law is involved, Lordship, regarding the approval of the central
Learned
government.
single judge has held that your application has become infructuous.
Lordship, but that letter will continue, Lordship. So I pray, Lordship, session is going to over, Lordship, he is suffering like anything.
In any event, sir,
Lordship,
the matter has to be heard after considering arguments of both sides. So we will give a date, there's not a difficulty. Re-notify on 24th July
Much obliged.
after showing the name of Mr. Gupta in the court list. Reflecting the name of Mr.
Item number 9.
My Lord, this case is regard to whether compensation can be granted with regard to the jirat in a government land matter.
Yes.
I came across two judgment matter.
Yes, difference in opinion, that is why it has been referred to a larger bench.
Yes.
Yes. Yes, please.
My Lord, Para 17 also, my Lord, I'm relying on the Supreme Court judgment, man.
This D. Hanumant,
It's a
D. Hanumant, sir. Which judgment?
2010, 656, 10 is so.
Yes, there are 17.
My Lord.
Land already stand acquired. But in this case, there is no dispute that the land is government land.
Yes, ma'am.
That we have seen.
God, yes, since a government cannot acquire its own land, my Lord, the question of jirat does not come, my Lord.
Zirat has nothing to do with ownership.
Since its status itself is an encroachment, my Lord.
Maybe. But that is a permissive possession. So whatever crops are standing thereupon, read the provisions of the Act, LR Act 1894.
My Lord, the old act, my Lord,
Old Act,
1894,
that's what we are calling for.
section 3A, my Lord.
Person interested. It's not as simple as it sounds, Mr. Counsel. And one view has already been taken in relation to same land,
Yes.
which the order was not challenged. So what is the reason to take a different view? Read section 3, please.
Yes, 15.
Regarding land, of course, they will not be entitled. Only Zirat. Read 3B, please.
Affected.
And even 3A. You have 1894 Act,
Yes, sir.
read 3A.
Yes, 15. Old act. Thank you, sir. My lord, for the purpose of enabling the state government or the commissioner to determine whether the land in any locality.
What were you reading, sir? 1894 Act,
Yes, my lord, 1894.
Section 3, subclause A. In this act, unless there is something repugnant in the subject or context.
Yes, my lord. The expression land includes benefit to arise out of the land and the things attached to the earth or permanently fastened to anything attached to the earth.
And read 3B also.
Person interested include all person claiming an interest in compensation to be made on account of the acquisition of land under this act.
Yes, and then read 9. Persons interested, it's not only owners. If they were occupying the land, maybe in capacity of encroachers.
My lord, in this, matter, I beg to submit that person interested, my lord. But since this, when the land is acquired, my lord, now my submission would be it's a government land, my lord. It can be acquired. Since the question of
3, subclause 393.
the collectors shall also serve notice to the same effect on the occupier. If
Occupier. So there are two categories of persons to whom notice is to be served. Persons interested, that would be the owner and the occupier also. So occupier, why it would not include a person who is encroaching and who has cultivated the land in question? Need more preparation on this. Bring out the law.
let it come after vacation, madam.
That in that there is no difficult land council for respondents. Pray for time to prepare and argue the matter. List after summer vacation.
I have a
Obliged.
prayer. Lordship, finally, the name of the revenue department may be reflected in the cause list. I missed the-
Attendance of council appearing for the revenue department. Government council appearing for the revenue department shall also be mentioned in the cause list.
I'm deeply obliged. Your Lordship.
Item number 10.
In this case, Lordship directed the principal secretary to file the affidavit. Yesterday, principal secretary sent it after getting it, my lord. Some more corrections are required. 3 days time required, my lord. By Monday we file it.
And standing council was not, yeah. Brings for submit that some more time is required to file affidavit on behalf of the principal secretary. KAC. Re-notify on 19th July.
Always.
The affidavit shall positively be
My lord.
submitted in the intervening period.
Item number 11.
Lordship, as per last word and Lordship, the respondents was. to be-
Affidavit.
Yes, Lordship, today morning I have received the instruction, so I may be allowed to extend to filing affidavit, Lordship.
The direction was already given.
Lordship,
Two
today,
opportunities have been given, two rather three. Since March, we are giving you the opportunities.
today morning, Lordship, I have received the instruction. Lordship.
That is your problem. Earlier, Madam M. Bhattacharya was appearing. The file changes hands in the government departments. For that the court did not wait. It's totally uncalled for. Already we are giving you one more opportunity. What's your good name, sir?
HK Hazarika, Lordship. HK Hazarika.
Mr. H.K. Hazarika advocate puts in appearance on behalf of the response numbers 1 to 5. He submits that he has been instructed to appear on behalf of the respondents recently herein before and needs some more time to file affidavit on behalf of such respondents. Last opportunity is being granted for now. List on 26 July.
Item number 12 to 48.
Your Lordship. Lordships, in this matter, Your Lordship, the personal appearance were called for. And the Deputy Commissioner Kamrup Metro is here, Your Lordship. Lordship, also, I would like to have a look at the updated status report, Your Lordship. regarding the various institutions where encroachment is there.
You're supposed to provide a copy
Yes, Your Lordship.
beforehand.
Yes, sir.
Then,
I apologize, Your Lordship.
hmm,
I apologize for that.
because then how will the other side respond, madam?
Exactly.
Give a copy.
I have, Your Lordship. I provide-
Learned Counsel MS Borduloy has placed on record the status report issued from the Office of the Deputy Commissioner, Kamrup Metro Land Settlement Branch dated 19/6/2023. Copy of the said report be provided to Land Counsel representing the appellants oblique petitioners in all the writ petitions. You are representing all of them?
No, my lord, I am representing in item number 12, 13 and 15.
Already you give a copy to everyone. Re-notify on 26 July.
Also, Your Lordship, may I?
Personal presence of the Deputy Commissioner is exempted for the next date of listing.
I'm a pleasure. A pleasure.
Item number 50.
Lordship. May I please his Lordship, the engaged counsel, Mr. ARV is on land, so Lordship may kindly pass over the matter for the time being.
Who is appearing for the respondents? Union of India. H. Gupta. Pass. Password matter call करते हैं. End of the list था ना ये?
Item number 51 to 54.
Why? There is a matter to be taken up at the end of. You are calling out hearing list. No, first take up that password matter.
My lord, we are continuing with the work. It can come after vacation, my lord, this item 51 to 54.
As prayed by Mr. Senior Counsel, Mr. Chaudhary, comma, and since the petitioners are, this is fishery settlement.
No, my lord,
Then-
this is something to do with transportation of food
Submit,
grains and
Senior Counsel, Mr. Chaudhary, representing the petitioners, appellant submits that as his clients are continuing with the work, comma, there is no urgency in these appeals and they may be, the hearing thereof may be deferred. Accordingly, list in August, list for hearing in August.
My lord. Deeply obliged.
Date may be given, my lord, in the-
August,
sure.
date there is 8th August.
My lord. 51 to 54 बोल रहा है.
Pass over matter, item 6.
Matter was called out twice. No one appears for the appellant list after summer vacation. Now you can call them anymore. Yes, take it, take it. Call it out.
Item 50.
15 or 50. 50. Matter was called out twice. Appellant's counsel is, petitioner's counsel is not present. List of summer vacation.
For hearing, item 55.
May it please the Lordship.
Hmm.
Well, here, our appointment was interfered with by the learned
Appointment as
as constable, my lord. Excess
constable.
constable was
Okay.
interfered with by the learned single judge, my lord. Some unsuccessful candidates, my lord, preferred a repetition, my lord,
Hmm,
challenging the entire selection process.
hmm.
And in that selection process, we are not the party respondent. Subsequently, we have been implemented as party respondent, madam. And implement was allowed, but they have not filed any amended repetition challenging our
Selection.
selection, madam.
Yeah.
But learned single judge was pleased to allow the repetition and was pleased to interfere with our appointment.
On the ground.
On the ground that, my lord, our age condonation, relaxation of age was not done as per law, my lord.
All right, let us see the provision of law then.
My lord,
That's the only issue.
That
Age
is the-
relaxation.
that is the only issue, my lord.
Let us see where,
In fact, my lord, some of,
where
two-
this,
two
where this
petitioners-
aspect has been dealt with. Let us see.
yes, my lord. Impugn judgment.
Para
page-
13.
Page 100, my lord.
Para 13.
Yes, my lord.
Page 107.
That is the finding of the honorable.
Or rather
Supreme Court.
uh,
come to
And para 10 of the.
para 10.
10 of
Yes.
the husband also.
Discussion and decision starts from
Para 9.
para 9. my
Para
lord.
9 also.
Yes.
May I read, my lord?
Hmm.
To deal with the argument against the overaged candidate, the requisite pleadings are available in the impleading application, that is, Miss case number so and so, as also in the compilation prepared therefrom by the writ petitioners. The respective date of birth of the average appointees can be seen from the annexed gradation list. This list shows that the respondent numbers 11 to 19 were born on various dates between 15/6/1968 to 26/9/1972. Therefore, they did not fulfill the upper age limit of 38 years.
Let us see the office memorandum. Let us see whether by the office memorandum,
Yes, ma'am.
power which is not available in the rules, that can be conferred on the excise commissioner. Let us see the rules first.
Okay.
Whether the rules talk of any such power of relaxation.
That is not there, my lord, in the rules.
It is not there, it can't be done by an executive instruction.
Okay.
That is a substantive right which is being created.
In fact, my lord,
Whether the rule, if the rules
the government of Assam follows this office memorandum, my lord.
immaterial, sir, it can't be done.
On the basis of
You
that.
are a counsel for the government of Assam in numerous cases for
Yes,
other
yes,
departments.
yes.
Tell us such a power of age relaxation, which gives a right of selection against a public post. Can it be done by an OM when the provision is not there in the rules?
Okay.
That is sufficient ground to interfere.
Rule was silent about that, my lord.
The silent means there is no power to relax. OM can't confer the, let us see the OM.
Yes, my lord.
Yes.
Page 110, my lord.
Yes.
It's dated
That is a type
27th
copy, lord.
March 1980. That is a type copy, my lord. The original copy is page 112, my lord.
Mr. Chaudhary would say that this power can be only exercised by taking reference to power conferred by 309. This is making a stipulation in the service conditions, which is provided by the rules.
In the OM, my lord, government
Yes.
after due consideration are pleased to lay down the following revised principle for guidance in dealing with the cases for relaxation of age limit under the state notification. Relaxation from the fixed age limit is to be granted only in the interest of fair dealing or in the public interest,
interest.
and one of these conditions must be satisfied before the age limit can be relaxed in favor of an individual candidate. The relaxation is to be granted under power conferred in the notification by the appointing authority. In the case of appointment made by the governor, the appropriate administrative.
This is ex facie unconstitutional. Ex facie. Give us one judgment which says that the age relaxation for being selected on a public post can be done by an OM. It has to be the power has to be there in the rules, and the power has to be exercised by the appointing authority. No one else.
In the rule, power has been exercised by the appointing authority here, my lord. But rule is silent about this, my lord.
Read clause 3, that makes the things clear.
In case of direct recruitment to the lowest cadre of post through the Assam Public Service Commission, as per the provision of the service rules regulating recruitment to the various services and post election up to the age of 40 years may be granted in accordance with the procedure prescribed in subpara 4 below. Such relaxation may be allowed only in case of those who are in the service of the state government. In case where the direct recruitment is not made through the APSC, the relaxation may be allowed to those who are not in the service of the state government.
It's very vague. Clause 4 says the relaxation of rules. There is a question of relaxation of rules by an OM.
But clause 1, my lord, specifically said about the.
Give us one judgment, sir. You have got any judgment on the point?
What's it? That's when that is 1997 as 6XC 614. It is Dr. Amilal Bhatt.
Amilal, but yes, we know of that judgment.
That was discussed by the
That
honorable
was
single
discussed
judge.
in the judgment. Lordship. It was not in public interest. Lordship.
That is going on the issue of public interest.
That's-
Here we are talking of power to relax the age without there being any stipulation in the rules.
No, Lordship.
Secretary,
Here, my lord,
clients don't stand a chance.
In fact, my lord, page 44 of the writ appeal, my lord, 3 candidates, my lord. They are not otherwise overaged, my lord. Page 44. This is the miscellaneous application, implementing application filed by the writ petitioner. Here, my lord, there is a chart, my lord, paragraph 7. Last 3 candidates, 726, 727, and 754. Ganesh Das, his date of birth is 26/9/1972. Jyotirmoy Kotoki, his date of
We are not on the issue. If there is no age relaxation provided, why there can be presumed that there is no intervention. If they are already within the age limit, where is the question of granting relaxation?
Yes, sir. They are otherwise within the age limit, my lord.
But then why was the age relaxation granted? If they were within the age limit, why?
Well, in fact, paragraph 8 of this miscellaneous application,
Yes,
kindly that the applicants begs to state that even if the respondent authorities take the stand that first day of January of the year of advertisement ought to be taken.
let
as
us see the
cut-off
rules
date.
first. Let us see the rules. Where are the rules? The rules must be prescribing the age limit.
Here, well, 38 years.
38. So you are tinkering in the mandate of the rules by an office instruction, executive instruction, you can say, without making an amendment, whether that is permissible. A simple service jurisprudence, common sense, pure.
But these 3 candidates, my lord, they are within 38 years, my lord.
While deciding, we may observe that those who are within the age limit, as per the rules, they may be considered to be retained for retention. Others can't be.
But my lord, we have rendered
Immaterial.
more than 10 years of service.
Yes, read Alka Ojha. Read Alka Ojha. 5 years service as motor transport inspectors. They were not qualified to hold the post.
When I am relying on a judgment in this regard, my lord.
Let us see, sir. What judgment?
P.K. Ramasandra, Iyer,
Yes.
1984 2 SCC 141.
What is the issue? Let us see.
Here, my lord, paragraph 46. May I read, my lord?
Yes.
It is not possible at this stage to reject the entire selection on the ground that the ASRB committed a serious legal error in prescribing minimum qualifying marks at the Viva Voce test and drawing up merit list on.
That is entirely different controversy, sir. These people fall in the category of not being qualified by virtue of being overaged from getting into service. Give me the judgment of Alka Ojha. 2000. We have just relied upon it in one judgment recently. 2012 SCC most likely. 12 or 11 SCC.
Before 2 SCC.
अभी हमने किसी में judgment में use किया?
834
आपने लिखा ना?
2 SCC 141.
What was the name? Arjun most likely. No.
A person of any rule. A person of any of this rule.
That's not the. See, Mr. Katiyar,
Yes, ma'am.
your issue is answered in para 12, the judgment in the FCI, even assuming that there is a power of relaxation under the regulations.
2005 TSSC 618.
So the Supreme Court went a step ahead, assuming that there is a power of relaxation in the regulations. Herein, the regulations do not give any such power. And it is the obvious reason that constables, the recruitment to post of constable, the persons have to be fit. And
Otherwise,
if they are overset, obviously,
otherwise there is no dispute that we are not unfit because we have
there's no
participated in the.
question. There's a presumption younger people are there in the fray. Why should older people be appointed when they have crossed the age limit?
My lord, give me some time, my lord, so that I find out some.
Tomorrow? All right.
Yes, my lord.
Find out.
Day after tomorrow, my lord.
Day after tomorrow. And you too come with a judgment wherein this concept has been considered.
Food Corporation India Limited, that is there also. In the 2005 SSC, TSSC 600 Food Corporation versus Anulot and others. That was
What is the principle?
when the.
Food corporation,
Food
that is relied upon. We'll get better judgments directly on the point that where there is no provision of relaxation in the rules, it can't be done by an executive instruction. Day after tomorrow.
Obliged, Lordship.
Item 56.
Yes,
Lordship, the matter may be adjourned as Mr. D. Gogoi is not well.
not feeling well.
He's not well.
Mr. D. Gogoi, and counsel present in the respondent is reportedly unwell, list after summer vacation.
Item number 57 to 62.
But I was required to bring the number of candidates who had applied, who had passed in both the papers in TET and who had passed with grace marks. My lord, the original paper is coming, but otherwise 6,409 candidates having passed both the TET papers on merit had applied, and 1,266 had applied with grace marks.
Okay.
Out of the candidates who had been given grace marks, 1,266 had applied. And have been 1,266 have been appointed with grace mark. I'm sorry.
1,266
1,266 have been appointed. I'm sorry.
with grace
Yeah.
marks. And how many were the candidates available
My
without
lord,
grace marks?
Without grace marks, 6,409 candidates who qualified had applied in the.
Including the appellants here. Presumably.
Yes.
So
6,409 total had applied, and
so
1,266.
this is on the face of it an example of arbitrariness.
My lord.
That you are giving precedence to persons who have been upgraded by grace marks.
No, I'll just, if I just explain the situation that was. The appointments are made on the basis of the marks obtained in the higher secondary, the graduation, the TET and the BEd examination, total taken together. In case
But a
of the
person who doesn't qualify the TET, he is not, that is fact,
in
that is the
case-
basic requirement,
Yes.
fundamental requirement for being appointed as a teacher. Now you have ample number of people who are qualifying by virtue of clearing both the papers with 60% marks. Now, why are you required to undertake the exercise of scaling?
But those candidates who have passed with grace marks, we did not take the grace mark into account while.
Immaterial.
calculating
If,
while calculating
why
the-
they are supposed to come into the fray? They did not qualify, they did not qualify.
The TET examination and the recruitment process are two very separate issues.
That's true.
So when the TET examination was held and we were not having the enough number of candidates, we saw
That is what the question
very
is.
less.
Number of candidates means what?
But at
There
that
are-
point of time, we did not know what would be the number of vacancies or number of vacancies being advertised.
So at that very point of time, you took the exercise of qualifying them by giving them grace marks.
Yes.
When was the TET examination held?
My lord, it was, the results were declared on 4th of March, 2020.
And when were the grace marks provided?
Prior to that,
Prior to that,
and the advertisement for the recruitment process started sometime, my lord, in August.
same year,
Same
2020.
year, yes. And the last date being, last date for the applications for the recruitment process being on 7th of October 2020.
Advertisement
was
11/9/20.
11 September, it was, last date was 7th of October,
How many were the total posts?
my lord, 5,000.
5746.
5,746.
And how many have been filled in and how many are lying vacant?
My lord,
That I will have.
That statement is required, no? Obviously, if you have post vacant, consider them
Yes.
because they are otherwise qualified.
My instructions on the last occasion was there were no such post vacant for the. I'll just.
Because
Lordship,
in
will
one
give
another
expected
matter, we distinctly remember Bernard Advocate General making a statement
My lord.
that the recruitment was about 50% only.
There are 2-3 recruitments which were there. My lord,
don't know.
including the-
Come out with a
I'll
statement.
have to- In the, perhaps in the subsequent advertisement, it might have been that 50% have been filled up.
About this
This one.
recruitment, you just let us know what is
I'll
the
do that. my lord.
status of vacancies.
Lordship will give-
Tomorrow?
Tomorrow, yes. Of course, yes.
Mr. Mazumdar, praise for time, submits that the information in terms of the order dated 15/6/23 has been received and he shall be placing the same on record during the course of the day. He shall also keep available the exact figure of posts of on offer and posts filled in pursuance of the advertisement dated 12/9/2020. List tomorrow.
My lord, could it be there for tomorrow, my lord?
Let it be tomorrow. What is the problem?
In fact, there was a subsequent advertisement where out of 7,500 posts, they could fill up only 2,000.
2,000. That is what I think. That is what
That was the
Bernard,
subsequent-
Mr. Saikia was referring to.
Approximately 5,000 posts are lying vacant.
Still vacant.
And we are persons without grace marks, we got 60% in aggregate. Maybe I've got 70 in one paper, 54 in
then
the other.
again,
I've been left out.
But these are the candidates who have secured 60% in both papers. You are presenting those.
No.
No, my lord, I represent both both. Some who got the grace and so otherwise based on average, they are through.
Okay. All right. Day after tomorrow.
Obligement.
Item number 63.
None. None present for the party. List of summer vacation.